All right, good afternoon, everyone. This is the Florida Agritourism Association's monthly webinar, the first one for 2025. And we're very excited to welcome Timothy Riley, our very long-time friend and legal guru. Currently, he's practicing government relations and administrative law with Gunster Law Firm in their Tallahassee office. He's originally a Texan, but I consider Timothy a Floridian by now. He's also serving uh, with I'm so sorry, Timothy. Timothy is with the Army National Guard and has served with Operation Enduring Freedom during the Afghanistan years. And he also is an adjunct professor at Florida State University's College of Law. Today, we are pleased to offer you a bird's eye view about how to help agritourism operators with private roads and their operations and the definitions. And Timothy's going to provide some really good tips and answer all your questions. So with that, I'm going to pass it off to Sarah first for any housekeeping and then Timothy.
Hi, everyone. Welcome to this afternoon's webinar. Excited to have you. I will keep an eye on the chat box. So if you have any questions for Timothy, just drop them in there and I'll keep an eye on it and we'll interrupt as little as possible. But if it's timely, I'll go ahead and interrupt Timothy and ask the question. And, excuse me. We are recording it, so I will be sending it to everyone after the webinar completes as well. All right, Timothy, thank you.
All right. Thanks, Lena and Sarah. And thanks again for the Florida Agritourism Association. What a great group, and glad to have been part of it from the beginning. And I think this is probably the second or third time, at least definitely the second time that I've done the webinar in January. So I don't know if January is going to be like my spot to talk, but I always love doing the webinars and love coming to the conferences. They get better and better with each year. So thank you very much for having me. Today, we're going to talk about a very, very exciting topic. We're going to talk about roads, which I've realized I've had a number of clients over the last several years that have had conflicts, mostly with their neighbors, about the use and access of farm roads. And then whether they are private or whether they're public, and if they are private, what rights and obligations do farmers have when they add an agritourism activity onto the property and start putting additional burdens on that road? So thought it would be a timely topic to discuss that. If your agritourism business is on a public road and you don't use any private roads, then probably not going to get a whole lot out of this. But if you do have a private road, or if you don't know whether you're on a private road, then hopefully this will give you some good information. And in terms of, pun intended, here's the roadmap that we want to follow. Here are the number of questions. I'm formatting this presentation based on questions that I've had to address or my clients have had to address over the years about the use of private roads. And so we're going to walk through all of these at a fairly high level. We've already done the introduction. There's the obligatory selfie photograph of me here. One of the few times I actually wear a tie. Got to do the disclaimer for the liability practice. For all purposes as it relates to liability and malpractice, I'm just a dude on a Zoom talking to you. All right. I'm not representing anybody. I'm not giving anybody specific legal advice. Please don't do or not do anything based solely on what I tell you today. Make sure that you confer with an attorney. If you don't have an attorney, my contact information is at the bottom. But do your own research. And the reason I do that is because when it comes to private roads, and I've dealt with a handful of instances over the years, what I have found is it's very fact dependent as to what the law does or does not do as it relates to your activities. The statute does not dictate most of what you deal with when it comes to roads. It's going to be based mainly on common law, and how that law applies to your particular issue is going to vary. It's going to be almost 90% depended on the particular facts. I've never had a private road issue where the facts were the same across the board. So that's why I say I really need, you really need to talk to an attorney, really lay out all those facts so you can get some good legal advice. And that's why my presentation today is going to be at a fairly high level. So it's common law, so you're going to be dealing with case law, judge-made law for the most part. That's dealing with a bunch of cases. This presentation is not going to be a bunch of slides with a bunch of different cases where I talk about the facts of the case and tell you the rule or whatever. One, that doesn't really help anybody for the most part. And two, it's not really necessary. What you want to do is you want to issue spot. And what I want to be able to do is give you a vocabulary and give you a scope of how these roads work so you can identify a potential problem. In many instances, I've had clients where they didn't realize they had a problem until something came up. So this is going to help you issue spot. And then from there, you can work with attorney and get into the more nuts and bolts as to how it applies. So this is the common scenario that I get, and this is how I'm basing the presentation. You're a farmer and rancher, you've been farming and ranching, you add agritourism as an additional activity onto your property. And in doing that, you've increased vehicle traffic on these rural roads that often serve a number of different farms. And those rural roads may be semi-improved or unimproved, they may be gravel, they may be dirt. They may have signs, they may have names, they may have farm road designation, they may have something. And you've never really cared one way or the other on what the road is. You know that you use this road, other people's use this road, and this is how it's always been. But you start doing activities that's bringing more and more people from the public onto this road to your property, past all of your neighbors, more so than you would otherwise with just your underlying farm operation. Neighboring farmers start getting upset. They start complaining about increased traffic, noise, dust, and damage to the road. And this damage to the road may be a road that you've participated in repairs in the past. You may have not done any participation in repairs. And you're typically, my clients are like, well, I'm just using the road like everybody else. It's a road, deal with it. And then what happens is that neighbors start interfering with the use of that road. They start threatening legal action. They start contacting local law enforcement. They start contacting the county, complaining about the road, saying you don't have a right to use the road. And all of a sudden it starts creating problems for you. This is how I've done a handful of these. This is almost how it always starts in each of those instances. So the critical questions that I want to talk about just right off the bat: is the farm road that you're using a public road or is it a private road? And it's kind of interesting to know. Sometimes it's difficult to tell. You would think that'd be pretty easy. Like, is it, does the county, is it county road or is it a driveway? You think it's kind of one or the other. But there is a potential gray area. You may think it's a public road because there's a sign and there's a name and it shows up on Google Earth. You're thinking, well, of course that's a public road. All roads are public. It's not on my land. But you might find out that it really is on your land, or it's not really a public road, but it's an easement right on somebody else's property. So the first thing is to do, what is it? Is it public or private? If it is a private road, what rights, limitations, and obligations do you have? What can you do with it? And is your agritourism activity allowed, or do you need consent of other landowners to be able to do that activities? So those are the three questions that are going to drive the analysis that we want to talk about today. So the first thing we want to talk about is, what is a private road?
Timothy, before we jump into private, there was a question about related to any considerations related to federal roads versus state or county roads. I know you're focusing on private, but do you have an answer?
Well, from this standpoint, public road is any road that's going to be owned or controlled or maintained by the government. So whether it's federal, state, county, that's all there. And essentially, if you've got a public road, then almost none of this analysis applies. So it's going to be, and that's where we're going to start getting into is, what is a public road? What is a private road? We'll talk about that right now. So I'm lumping them all together from an analysis purpose on whether your rights. It's not going to really matter whether it's a federal highway, state highway, county road, or municipal or city-owned road. So a private road are going to be roads that are not owned, maintained, or controlled by the government, but by private individuals or entities, right? So typically you'll see a public road will be done by dedication, right? There's going to be a new development or something like this. And then whether it's been done 200 years ago, 100 years ago, or 2 years ago, there'll be a dedication of private property to a governmental entity, whether that's FDOT, the county, or the city, conveying the right of way of that road to the government for the purposes of the benefit of the public. What are private farm roads? Farm roads are essentially roads used or created by private property owners to be able to get onto and through and around their property. And again, this is like Google AI trying to create for me a subdivision of a farm. It's a little weird, but whatever. It was the best I could find on the internet using AI. And so what often happens is you have these, in the rural areas, you have these large, farms or ranches that were acquired, maybe even going back to the Spanish, claims or whatever, but you'll have these, that over time become subdivided. So you'll have internal roads, farmer ranch roads, internal to the farmer ranch to get to all the different parts of the farm and ranch that connects to a public road. And then over time, that ranch or farm is subdivided. And as part of the subdivisions, there'll be conveyance of an interest to be able to use the internal network of privately owned road. So all the different farmers and ranchers can still get access to the public road. And that's what often becomes a private farm road. And these conveyances, and again, all the images and everything I'm using, I tried not to get anything that was in Florida. I know this is about Florida, but I didn't want to accidentally grab one of your farms and throw them up there or accidentally one of my clients. So I'm using examples that are going to be from all over the place. And so, but here's an example of an issue, not an agritourism issue, but an access issue for one of my clients in Maryland. And then it just happened to be a good example to do this. So when you subdivide a farm and the original grantor of that larger farm giving out the different estates of the farm as part of the deeds for those smaller tracts, you'll usually have some type of conveyance. And this is here an example. Again, this is Maryland, not Florida, where they'll say there's a conveyance is subject to a right of way across a description of property. And so, when they subdivided the farm, they carved out a private right for you to be able to go across other people's property, usually on an existing farm road, so you can get to a public road. And you'll have this, hopefully, as expressly provided in the property deed for the farm that you own. And these private farm roads, they can be created by a number of different means. And this is why, again, it's very fact specific. They can be done by express or implied grants, reservations, dedications, prescriptive or adverse possession. So they can be in writing, and they can be in writing in different ways, or they could just be created by historical use. These can be done by easements, licenses, or covenants or restrictions. There's a number of different legal mechanisms to do it. These private roads can serve different purposes, right? So when you get these conveyances, whether it's in writing or not, it could have been done for a limited purpose. Like you're getting access across another person's property on this road for access or for drainage or for utilities or for specific recreational purposes. There may be limitations that you're only using it for agricultural or transportation of crops or livestock or equipment. It may say nothing. It just may say you have access to this road. It can be located on a single parcel of land or across multiple parcels of land, depending on how that larger farm was subdivided into smaller farms. And these roads can be affected by a number of different changing circumstances for further subdivision, development, or conservation easements or whatnot that are put onto the property. Public or private? How can you tell if a road is public or private? The first thing you want to do is you look at your deed to see whether it specifically calls out whether that's it. But one of the things you want to look at is ownership and maintenance. So private roads are typically owned and maintained by private individuals or entities, whereas public roads are owned and maintained by governmental authorities. So if you're using a semi-improved or unimproved road, to get to your property, one of the things you want to look at is, well, who maintains it? Do you maintain it? Do your neighbors maintain it? Is there a covenant between the neighbors to do it? Is there something in writing that the neighbors will do something, or by practice have done it? Or do you see the county out there, periodically grading it, or taking care of it? Now, this is a gray area, right? This is a red flag. In some counties, counties will provide some maintenance to private roads, and sometimes there's a program where they provide some minimal maintenance. There's a program where they do a cost share with the landowners. Sometimes they just do it to be able to provide better EMS, emergency and fire access to rural properties. And so they may maintain or do some limited maintenance on a private road. So just because you see the county out there working on it doesn't necessarily mean that it is a public road. Access and use. Public roads are going to be open for use by the general public, while private roads may be restricted access, limited to certain individuals or groups. You want to look to legal documentation. You're going to look to your deed. You're going to look to a plat if there's one. You want to look to other legal documents, whether there's a covenant or on your property, or whether there's a contract between the neighbors that carries down, that runs with the land. What you want to do is you want to look at your title policy. If you have a title policy, you want to start looking at those exceptions under that policy to see if any of those exceptions deal with an indication that the property doesn't have direct access to a public road, or there's other easement, there's other interest on your property, or your property identifies an interest that you have on somebody else's property. So that's going to be a really good place to look. Other things you want to look for: signage and markings. Public roads are going to have official signage and markings. They're regulated by government standards. Private roads may have signs indicating private use or restricted access, and they may look different, may not have that green border, the standard green one, or blue, or whatever it is within the municipality or county that you work in. Again, don't use that as an indicator, right? You may have a street sign at the intersection of a road that the county put up, looks exactly like everything else, but it may be an intersection between the public road and a private road. And so that's not just can't just completely go by that. Historical use. You want to look to the road to, who's been using the road. Is it being used by the public all the time, or is it historically only been used by the property owners on that street? And government records. At the end of the day, you can always go to the county transportation department, or to the city or FDOT, and go, hey, is this a private road or a public road? Most of the time they can give you the answer. I can tell you that they don't always know. And sometimes they'll have to say, you know what? We don't really have a clear record of it, right? Because when it comes to their GIS and their road mapping and everything like this, they may map it or they may not have it mapped. And just because they map it, and just because it shows up on Google, and just because it shows up in their EMS response, maps, doesn't mean it's necessarily public, right? So I've had instances where, particularly with FDOT, where I've gone, hey, when we deal with this intersection, or we're going to do a driveway, or we're doing this thing, do you guys own it or do you not own it? There's sometimes they'll just we go, I don't know. We're going to have to do the same title research you're going to have to do, because we don't know. But most of the time, they should be able to give you an answer. Private roads as easements or licenses. So how are these roads created? They're most often created by an easement, and there'll be an easement to the benefit of your property, or an easement imposed on your property. And for folks who don't know anything about easements, easements are these legal mechanism of a non-possessory interest in land that allows the holder of the easement, which we call the dominant estate, the benefit, to use or enjoy portions of another person's land, that's called the serving estate, for a specific purpose. The easement can be created expressly, meaning in writing, or it can be done implied by mean practice. It can show up in the form of a grant, a reservation, a dedication, or by prescription or necessity. It can be something pertinent or engross. A pertinent means it runs with the land. It doesn't matter who owns the property, that benefit or that burden is going to run with the land, irrespective of who owns it. Engross means it's an easement benefiting a specific person or entity, and it doesn't run with the land. So you're giving a right of access to Joe, and once Joe loses that right or gives it up or passes on, doesn't go to Tim, or doesn't go to a successor in interest. It really is, it's limited to a specific person. A license is essentially a contract. So an easement is a real property, is essentially a real property instrument. It has contract application to it, but it's a real property instrument. It's like a deed or anything else. A license, now we're just talking about a straight up contract for the most part. It can be revocable. Typically it's revocable, which means you have a right to to use this road or driveway on my property to get to from point A to point B, so long as I grant you that right, and I can revoke it to you whenever I want. Does not create a property interest, but it's a contract. It can be oral or written, and it can be terminated by the lessor, usually at any time, unless there's a specific provision in the license to provide notice. Many private roads are created by easements. Some are created by licenses. Most of the time, you're going to see these easements that are recorded for the benefit of the property or against the property. What rights do you have? And again, this is all kind of the setup to go, if you are on a private road and you're getting into disputes with your neighbors, that dispute's going to be that there is a private road. That road is going to be on somebody else's property. And it may be on everybody's property getting out to the main county road or to the state highway or whatever it is. And one or all of those people between you and getting to the public road are complaining that you are exceeding your rights to use this private road. So what we're trying to do is set up, like, what are those rights? How did this private right be created in the first place? And what rights do you or do you not have? And it's going to come down to always the nature and scope of the easement itself, the four corners of that document. What does it say or what does it not say? And a lot of times, particularly if it's an older instrument, it says a lot less than what you would hope for. It's not very clear on what the rights are. So then we're going to apply case law. We're going to apply what we call the principles of equity, or basically where a judge decides what's ultimately fair. And again, that's why the facts matter a lot more than the law necessarily, because a lot of this can be equitable arguments as opposed to legal arguments. So there's a number of factors in determining the rights of property owners. And this is just generally a list of factors that we want to start thinking about. You're going to look to the language and terms of the easement itself. You're going to look to the four quarters of it, or any evidence of the party's intent going into the words that actually show up on the document. You want to look at what the purpose and use of the farm road and whether it's consistent with the easement or license. So how are you using that road? How does that compare to the language in the easement itself? The location and dimension of the farm road, whether it's fixed or variable. Does the road's width change as it goes across different properties? Is there specific language in the easement that it's a 10-foot farm road, or does it just make reference to a road? Does it even make reference to a specific road, or does it just say access across the property? The duration and exclusivity of the easement or license. Is it perpetual or temporary? Is it in gross or impertinent? Has it been passed from one entity to another by express transfer of it? Or is it something that runs with the land irrespective of who's using it? And then you're going to look at how the document distinguishes the obligations of the dominant and servient owners. The dominant one being the one that has the benefit of using the road, and the servient's the one that has to give up their property for the use of others. How do those things play out in terms of obligations for maintenance, repair, or improvement, and what has historically been done by these folks, and what's being done to interfere with one person's use or interfere or create additional burdens on their property. The three common issues that we see are going to be obstruction, maintenance, and termination. So obstruction is going to be when the servient owner or a third party blocks, impedes, or encroaches on the farm road, or otherwise prevents or limits the other person's use with it. In the agritourism context, that is the circumstance, and I've seen it, where people physically put up barricades that say, you're not, you can't use this road. Or they When you've got people coming to a wedding or something like this, they stand out on the road, or they put signs that says you're trespassing to all the passerbys. They only do it during your events, or they somehow try to physically stop or intimidate or harass the visitors, your agritourism visitors coming onto your property. Maintenance. This involves the responsibility and cost for keeping the farm road in good condition or repair or safety. So this is going to come up with, everyone's been using this road for farm operations and it's not heavily traveled on. All of a sudden you're doing weddings every weekend and you start seeing a bunch of ruts, you start seeing damage, you start seeing erosion, and then the question is as well, who's responsible for making who's responsible for maintaining the road? Does it get to the point where the road becomes unpassable for anybody else or becomes difficult to do it? And so whose responsibility is that for? And then termination is if there's something where there's an actual demand or declaration by someone that your rights have been extinguished from it. Like, you know what, you're perfectly fine using this when you were just hauling product, your farm products out seasonally. But now that you got people coming in here every weekend doing a U-pick, we're now going to issue a termination. And whether that's going to be, whether it's enforced by a judge or not, but we're telling you, you no longer have a right to use it. Big thing with obstruction is it's usually not just going to be a physical barrier necessarily, but it's going to be the concept of an overburden, which means you're using the road, or they claim that you're using the road in a way that expands or changes the road or otherwise exceeds or abuses the original intent of that easement. You're using that road for a purpose beyond what the intent was when this private easement was given to you. And that can result in a legal action where people can seek damages or injunction or a declaratory judgment that you don't have these rights to use that private road for this additional agritourism activity that you're adding to this area. The big thing with maintenance is just the traffic. Agritourism activities, inherently are bringing the public onto your farm, right? And which usually means a lot more traffic than what is typically seen on a private road. And again, whether these roads are well maintained or not, you can cause a lot of increased damage to it. And so this is where, again, it's very fact dependent. Is there an agreement in writing or not between the landowners that abut and use and have a right to use this road on the joint maintenance of it? A lot of times there's not. Usually just somebody every now and then when the ruts get too big or get annoying, they go out there on their own and fill it with gravel, or they may take their own front end load or whatever and do a bit of grading. And it's usually just done gratis, and it's done whenever whoever gets fed up with it and is done. Sometimes there's actual agreement, a contract that's recorded against everybody's properties that says this is the maintenance obligations for everybody. And it may be and it may be very detailed that says, okay, every year everyone has to kick in X amount of money, and there's an agreement to hire a third-party vendor to provide service for it, or there's periodic service and you have to pay a monthly due or a quarterly or an annual due for it. More often than not, there's absolutely nothing. And then the farmers or whatever just get together and go, hey, let's all go fix the road this weekend, is more often than not. So what happens when you're using, you have a right to use this road, and let's say there's not an issue with that, but your activity increases the damage on it. The farmer's going to you, hey, listen, you're now causing all the, more damage than everybody else. So now you have to fix everything. Do you have to fix everything as the agritourism operator? Maybe, maybe not. Typically if there's an increase there, if there's a appreciable difference in damage to the road that you can directly attribute to your additional activity, I typically advise clients, all things being equal, where there's not something where you probably do have that obligation. But depending on the actual legal relationship between all of the abutting users of the road and the burden property, that's a question, because particularly now where agritourism on the Right to Farm Act is a farm operation just like any other farm operation. So just because your farm operation is more intensive use of that road may not necessarily obligate you to make additional improvements above and beyond any other farmer using it for farm operations. And then termination again is by some mechanism where the parties seek to remove that right to use that road. Rights exceeding the burdens of the original easement. So the fundamental principle of easement law is that the easement rights cannot exceed the burdens of the original easements. It goes back to, and so the idea here is that the dominant owner cannot use or enjoy the easement in a manner that increases or alters the burdens on the servient estate, or impairs or diminishes the servient estate's right to use their property more so than what was given away when the easement was first put in place. And this idea is come to simple fairness. When this easement was created, it said essentially, hey, I own this land. I'm going to let you, as an adjoining property owner, cross over my land to be able to get to this public road. And we agree that you can use it for these purposes. And then they're spelled out. And if you exceed those purposes, you've exceeded that right. And we'll talk about it later, but that essentially becomes a trespass. And so it's really important to understand what legally defines the use and scope of that private road as an easement, because that's going to dictate what activities. So particularly if this land was subdivided 100 years ago, when it was a single lane dirt road, and your farming operation or your agritourism activity means that you are using it way more, or you've made improvements or expanded it, and whatnot. The question is, well, can you do that? Can you put that additional burden? And it's going to go back to essentially that original intent of that farmer when they subdivided it, or the farmers who came together 100 years ago. And for the most part, I'm betting you 9.9 times out of 10, these older easements do not account for or think about the future. It just simply says, here, use my dirt road, use this farm road to get to the county road. And that's it. And doesn't contemplate the future, and doesn't necessarily contemplate agritourism. More recent ones will, but most of the time you're dealing ones that are 40, 50, 60, 100 years old. And here's a great example for it when it comes to agritourism. There are some times where the easement itself will specifically say that it's meant for, you can use this farm road for agricultural purposes. Or it'll say you can use it for transporting crops and whatnot. So if it says you can use it only for agricultural purposes or transporting crops, and this was done 80 years ago, and now you're doing it for, you have a wedding barn or something else like that, that's going to be an interesting question as to whether your activity was contemplated within the scope of what 80 years ago people said agriculture was, or if it's something that's very limiting, like you can use the road for your farm operations, such as transporting crops and livestock. Such as transporting crops and livestock is going to be essentially defining the intent of what that agricultural use of that road is going to go. And you're going to have to say, okay, 80 years ago, how do you make your agritourism activity, wedding venue, look like or fit within that historic definition? Because if you take a strict reading of it, if it says agricultural purpose, such as for transporting crops or livestock, anything other than that could be construed as an overburden on that easement, and you may be prevented from doing it. So that's why the language of it is very important. Or if it's a small single lane dirt road, and it's constantly getting ruts or whatever like this, and you got a wedding venue, a wedding barn, and people are constantly, and you get complaints from the people that you're servicing that it's too bumpy and you can't get cars, you only can get trucks or whatever like this, and you go in and improve it or expand it, that may be an issue, right? Because if that limited 80 years ago, the intent was to keep it as this unimproved dirt road, and now you put gravel down and expand it by 10 feet or something like this, that may or may not be an overburden on the original intent of what that easement was going for. And again, this principle of the original intent is primarily to protect the serving estate, the one that the property that's burdened by having this road on it, right? Because they gave up a property right, they gave up a property interest, and the law is going to, is going to say they're only going to be held accountable up to what they were willing to originally give away. So you can't put anything above and beyond it. Now, this is not an absolute or rigid principle, right? Because it's a question of equity. And if over time there have been changes or increased uses or different uses, particularly if it's been done open and notoriously for a number of years, like decades, a court could say, yeah, the original intent was to limit for agricultural purposes for transporting farms and crop, but it's been used for all these other additional purposes as well. Now there's homesteads. Somebody has a farm service business or a repair shop that supports agricultural operations in the area. And that's been going on for 50 years or 60 years. They very well could say, over time, the use has been changed and has been accepted by practice or omission or silence by the parties, and they'll recognize that as a reasonable modification over time. But what I have to say is really important is going to come always back down to that original intent. That easement's a contract. And parties are going to be bound by what they put into that contract. And there are instances where you can go beyond that contract, but the judge is going to say, I'm going to look at this four corners as if it's plain and clear what the four corners of this easement said, then that's what's going to apply. And that may anticipate these farmlands turning into urban areas or being subdivided or additional burdens, and they may not. And sometimes they may say, you know what? It is what it is. It's very clear that the intent was to be maintained for a limited purpose, for a small scale, for the benefit of this particular, these particular owners, for this particular, traditional definition of agritourism. That is what it is. Doesn't mean the parties can't reach an agreement to do something else, but sometimes that's what it is. And again, it's going to go back to that four corners of the document, the plain and ordinary meaning of the words used. If there are facts that make you question whether the four corners of the contract actually have controlled the practice of the parties involved, then the court is going to start looking at prior use or necessity of the parties. Necessity of the parties we'll talk about here in a minute, but that's an important concept because that's going, at the end of the day, no judge is going to let your property be landlocked, which means it has no access to a public road, right? They will create a means by which you will get out to a public road for your property, because otherwise the property would have almost no value if it's landlocked, and that would be that's the question of necessity, private necessity to be able to get there. But what you can or cannot do, and the burdens on it may be substantially limited or whatnot. But they're going to look at what has been used, prior use, and they're going to look at what, if there was any decision that would be adverse to the dominant party that would prevent them from having any access whatsoever. And again, this makes sense, right? Because you want to promote the certainty and stability of the easement rights and obligations. You want it to be clear what the benefit is and what the burden is. Enforcing these rights. So this is going to be usually, we're on the wrong end of the V on this. So more often than not, it's not an agritourism operator necessarily suing the neighbors. It's usually the other way around. But this could go both ways. But this is in the context of, yep, you got a private road. The neighbors are complaining. They think you're overburdening it. You're using it for a purpose not authorized. You're doing it. You're overburdening it with your agritourism activities. These are the types of things they could be coming after you with. Could be an action in trespass, nuisance, or breach of contract. So trespass is a tort, and that's going to be, and it could go both ways. It could be, it was committed by you overburdening the property where you're like, okay, you're only allowed to come on here, my property to use this road to come on my property to transport farm goods. Anything other than that, you're trespassing on my property, and they can bring cause of action for it. On the flip side, if the surveying owner, um, the owner of the property that has the private road that you want to use, starts putting up barriers or other things that prevents you from using the farm road, you may have a trespass action for them because you have a real property right in that easement. And if they prevent you from, if they go onto your easement, which is shared by, it may be exclusively for your benefit or maybe used for a number of different people, but nonetheless, you have a real property interest. If they interfere with that property interest, it could be a trespass on their part. The nuisance, again, is on their part, suing you is going to be in the context of your use or abuse of the road is causing off-property effects. So it impacts off the easement that's adversely impacting their property, such as odor, dust, vibration, pollution, or damage to the property beyond your easement area. On the flip side, if they do something to interfere with or destroy or cause erosion or destruction to the road, you would have a potential nuisance action for them. For the most part, it's going to be someone saying, I was perfectly fine with you using my road when you were just using it for your farm, but now when you've got 100 cars coming up and down the road every weekend, the noise and the dust and everything, that's too much. That's causing me, it's causing a deprivation of value on my property because this road wasn't designed for that level of traffic. And then the breach of contract. And that's going to be where you go to the easement itself, the four corners, like, listen, the easement says you can do X, you're doing Y, you're breaching. You're in breach. And so basically, it's just like any other contractual dispute between property owners. Landlocked property. So kind of already kind of hinted at this. If you've got a property where you have no public access, and again, people think this is a little weird, like, oh, I always got access to the public road. You would be surprised the number of subdivided farm properties that are 100% dependent on a private road, sometimes for miles before they get to a public road, right? And they may cross 30 different properties on that private easement to be able to get to a public road, right? So it can be a significant issue. If there is some action or some dispute that prevents you from doing it, getting from one of those 30 people, landowners, right? That dispute's going to be looked at in terms of providing you at least some type of access, right? The court is going to find a way to give you access, and that could be through a number of different remedies. An easement, express or implied easement is essentially a remedy between the parties to reach a resolution on using it. If you need a court to do it, you're going to get an easement by necessity or an easement by prescription. And this is where the court's going to essentially come in and say, you're going to have these rights for your landlocked property to be able to get to a public road. And here are the burdens that can be placed upon everybody between you and that public road for that purpose, to be able to keep that property having some type of access, because you're always going to get some type of access. May not be the access you want, may not be for the scope of the activities you want, but you're going to get some type of access to get to the public road. And we don't need to go through each one of these. I want to make sure we got a little time for questions. So conclusions. So big picture, some things you want to think about. You want to confirm whether you're on a private or public road. If you've never actually confirmed it, you just assume that you're on one or the other, you probably want to know, right? You definitively want to know. You want to go look at your deed. You want to look at your title paperwork. You want to talk to the county, transportation department, talk to an attorney, talk to your real estate agent, do something, but make sure you know one way or the other. If it is a private road, you want to confirm what your interest is. How is that road? What is the legal mechanism that creates that road in the first place? Is it an easement? Is it a license? Is it a covenant or restriction on the property? Is it platted with this private benefit on it? You want to know. You want to know what mechanism does it. And you want to then confirm the scope and use obligations. And specifically, you're going to look at that in terms of your agritourism activities. So based on whatever that instrument is, or whether there is or is not an instrument, what uses do you think you can use for the benefit of your property on other people's properties? And you're going to look at that from your agritourism activity. If you've been a farmer or rancher and everyone else is a farmer or rancher, and all of a sudden you're going to add a U-pick or a wedding barn or something where you know you're going to be bringing people in on the weekends, you want to confirm that you legally have the right to bring that activity onto this road. And if your agritourism is potentially inconsistent with those allowable use, you want to consider what your available defenses are. You want to go, okay, within the legal mechanisms or within the agreements, verbal or written otherwise, do you have a defense to allow this activity? To allow your agritourism activity when you know those complaints will likely come. And if not, what proactive engagement can you do with these other property and easement holders to secure those additional rights that you need onto that road so you can be able to comfortably feel like you can conduct these agritourism activities without creating any further dispute with the adjoining property owners. And I've left 10 minutes for questions, which is about 6 minutes more than I usually do.
Thank you, Timothy. That was really thorough, very, very informative. We do have several questions. Lena typed in several. Are there guidelines or recommendations for private road maintenance, even if they're voluntary?
Whether there's guidelines, I imagine maybe there's somewhere. I don't know of any guidelines. I mean, I have worked on a couple of mutual maintenance agreements over time, and so you might want to talk to a real estate attorney or something like this, or a land use attorney. We'll probably have some examples. They're going to be with a more sophisticated one. I'm trying to think if there's been, CCRs that will deal with communal space and joint access with it, but typically what I see are these essentially fairly straightforward private contracts with the landowners that will they won't necessarily want to make commitments to actual money each year. Like everyone's going to put up $1,000 a year or something that goes into a pot, but there'll usually be something that doesn't have the requirements that says you either maintain your portion of the private drive that goes across your property and everybody else will maintain theirs to a particular standard, or there'll just be agreement that says there'll be an agreement to get together and reach an agreement. So it could be as simple as, hey, we all understand we all have to mutually maintain it. We're all going to, as needed, get together and in good faith find a resolution. So it can be pretty simple like that. Or I've seen this happen. I haven't done it. They will, if the county will do it, the landowners on that private road will go collectively to the county and see if they can enter into a county maintenance agreement where the county will provide some usually very basic maintenance for that road, subject to an assessment of the properties.
Do you know if the Rural and Family Land Grant Program takes access to private roads into account?
Oh, good question. So in the context of wanting to get a rural land grant easement or something for your property, whether you have to have public or private access.
Access.
Yeah, in order to be able to apply, honestly, I don't know. That'd be a good FTAX question. Maybe think we have somebody from FTAX on. I don't know what they look like. I don't know what they look for entitling purposes for you to be able to get the ag easement from them. So I don't.
We know someone we can ask, Timothy. Thank you.
Yeah, top of my head, I don't know.
When might be an example of the eminent domain changing the original intent of an easement?
Well, eminent domain, that means they, if a government entity with condemnation powers comes in and takes it, then it becomes public. So then you don't have to worry about it because now it's a public road. If it was taken by FDOT or by the county or the city, then it's public and you will have the rights to use it, subject to any limitation that the local government may have, which public access is public access.
Can you talk a little bit about creating an easement for the utility company to bring electricity to a barn on a property?
Mm-hmm. So most utility companies will have their own easement forms, and they're usually pretty simple. If it's just like running a line to it, they'll usually just specify that they're basically, a lot of times if it's just, just running power out there, they usually don't need a survey or something like this, but they're going to say, hey, listen, we're going to run power, and then we have to, you have to give us rights to be able to run it and maintain it or whatever. So they'll do it. They're typically going to be providing power for that area. I mean, so if they're the utility provider, they're providing electricity to all the properties. So they will, depending on how their easements are, they'll go off that. But they have their own mechanism for doing it.
Would you recommend amending the allowable use clauses in the original agreement with neighbors who have access to the private road?
I mean, obviously that's the best thing. So if you already have, if you have an easement for this private road, and say it's like old, it's one of the older ones that just says you have a right to come across this road, and you have a right of access. So, for example, if you have something that's real fed, come on, something that just says subject to restrictions and easements of record, if any, and this specifically says this, the conveyance is subject to a right of way across the panel described in the plat for grantor to gain access to retained lands for agricultural purposes only, right? If you've got something that's just this, and you could fight about this all day. And if the property owners are all willing to get together, then yeah, amend it to very clearly define what rights you have, add in the agritourism activities. And then typically what you could do is at that point, you could build in the additional obligations. So that's part of the quid pro quo of working with your neighbors. Like, okay, listen, we don't, none of us want to go to court. None of us want to have lawyers involved in finding this, whatever. Let's just agree what that scope is. And if you're willing to do that, then you can beef up these language and do it. But then, the flip side is that, oftentimes we'll do is like, okay, we're going to be very clear that my agritourism activities are going to be allowed. No one's going to give me a hard time about it. But you're also going to recognize that you probably have a disproportionate impact on the quality of that road. So you'll agree and you'll do it in writing that says you're going to assume a greater responsibility than the others for the upkeep and maintenance of it. And that's usually how you can resolve it. But just also understand the flip side of that is you want to be very careful about doing that, because if you take something that's very broad where you could arguably argue a broader use of it, and then you go in to provide a very specific use, you need to make sure that specific definition really works for you and contemplates the future of how you're going to use your property. Particularly if you have one agritourism activity, you get you really just, you got to dispute with people, coming on because you're doing a U-pick, and they're like, okay, let's fix that to allow your U-pick. But then 2 years from now, you're like, man, I really want to get into that wedding barn side of it. They may go, no, we expressly dealt with this, right? And a judge is going to be like, nope, you specifically came in and amended it and you wanted to do it. You're going to be held to it. So you got to be very careful about how you draft those things.
William was asking, where are the easement contracts filed? I believe this is back to the utilities.
So any easements that are recorded against your property, right, should show up in your title work, right? So when you bought the property, You should have your title policy. It will show them, they'll come up as exceptions from it. And that's going to be a good place to look for it. Otherwise, I mean, all the records, if to the extent it's a recorded public record, it's going to be in the county clerk's office recorded against your property. And the best way you do that is you just get it on title for you, and then that'll hit everything that's publicly known on against your property.
Thank you. Easement is for an unspecified access through 1.5 miles through neighbor farmers, cattle pastures, and gates. Can you speak to the responsibilities to the landowners, cattle, and gates?
Again, you want to look at the document. If it says you have a right to go across it, this could be an issue like, well, particularly with the cattle, is it like something where the issue of you have gates and you forget to keep a gate open and cattle escape? You could be on the hook for that. If the practice was, and the intent is that you go through, you got to make sure the gate stays closed. If there's a lock, it's going to be by the practice of the owners who keeps the lock, whether you double lock or whether you're responsible for the lock, or they're responsible for the lock. And if it's just going across the pasture, it's going to be very much probably dependent, and there's nothing else to it, going to be largely dependent on the historical use. So if you're just going across for your homestead, and then all of a sudden you now want to bring 500 cars across, right? You're probably going to have an issue with that, particularly if it's just going through open pasture. So your historical practice and use will probably become very important if it's that basic, where it's just here's a gate, you're allowed to open the gate and get across the property. It's going to be very much going, what was the intent of that use?
Well, we just hit the 5 o'clock hour. Excuse me. Are there any more questions? William, we actually, Timothy has done a webinar in the past about agritourism laws that I can send to you. And he does a great job at our conference. Hopefully you're planning on attending this July.
I wouldn't miss it. I owe you my sponsorship. I'm just waiting for my new budget to come in, and then checks on its way.
Great. We'll be back in Lake Buena Vista July 20th through 22nd for the conference. So we hope everyone can join us, but we'll have some more webinars in the coming months. We're always looking for subject ideas, so please send us a note, email, call us. There's been some really more specific issues that people wanted to know about, and this is a great opportunity to learn everything you need to know.
All right. Thank you, everyone. If we have no more questions, just
Thank
checking.
you as always,
That's it.
Timothy.
Yes, thank you so much, Timothy.
Appreciate it.
All right. Thanks, everyone.